All right. So you submitted a sworn proof of loss. You expedited the decision of the insurance company. At least in Florida, it instantly dropped from 60 days down to 30 days. How long is 30 days to an insured that can't utilize their house? Feels like 30 years. So you just saved this insured 30 years. 30 days for the people who are listening. But let's say there was something that you did not see. You were so ambitious to get this sworn proof of loss submitted, and or while going through the claim, something was discovered that you had no possibility of discovering. Are you able to change your sworn proof of loss? So, one thing that I learned and one thing that I did on every claim is included this statement. I screenshotted one of my proof of loss that I sent out. And you're more than welcome to use this. And I got this language from Stephen Bush. And I use it on every proof of loss, just letting them know that it's possible that I'm going to be changing it. The insureds reserve the rights that he, she, they, they were using pronouns even then. He, she, they may have under the policy, including but not limited to supplementing the claim or filing additional proofs of loss should cause arise. The proof of loss does not address hidden damages and does not include any unknown damages or complications or additional costs that may be associated with any repair, replacement of the damages to the insured property. Just including that simple statement can save you a lot of confusion, and it puts the insurance company on notice that things may change. All right. So we went down the rabbit hole. We know that our primary goal is to indemnify the insured as quickly as possible without forfeiting any of their rights. And we know in order to not forfeit any of their rights, we have to abide by the terms of the policy. And we know that when we looked in the policy, the duties after a loss said that we had to have a sworn proof of loss, signed sworn proof of loss. And we know that proof of loss, in order for it to be sworn, doesn't have to be notarized. And we know that depending on your state, you have to include additional language, right? And now we've submitted this as a public insurance adjuster. So my question to the room is it unlicensed practice of law for a public adjuster to assist an insured with a sworn proof of loss? I hear a no. Is there a yes?